Question here asking about clarification regarding AB 414 that went into effect January 1, 2026. How does that apply to multiple tenants? What does a landlord have to do? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, just to kind of quick recap, AB 414 was a bill passed last year. It went into effect last week, January 1, 2026, now requiring landlords to electronically refund security deposits or remaining portions of security deposits to tenants if they accept electronic payments. Okay, so this AB bill did some amendments to Civil Code Section 1950.5, the residential security deposit statute, and added a couple of provisions. So for starters, when does AB 414 apply? Well, it applies if, again, a tenant pays rent electronically to a landlord. Okay, so the law now requires that if you accept electronic forms of payment, or the successor landlord, let's say you bought a property, right, and you gave your 1962 notice to the tenant, hey, listen, I'll take electronic payments. Y'all got to follow this the code section for security deposits. What you have to do when the lease is going to expire, or when either party give notice to each other that they're going to terminate their month-to-month tenancy, the landlord has to notify the tenant in writing that they have the right to receive their security deposit or return of it, so to speak, by electronic payment, by the method that rent is paid, or by any other electronic method that landlord and tenant can agree to. Okay, we get past that part. Question is now, what do you do when you have multiple tenants? Okay, and the law is very specific about this. Okay, so the default is if there are multiple tenants on the property, what the law states, unless the parties come to some type of written agreement otherwise about electronic payment, the payment actually has to be made payable by check, with all the tenant and all adults that are on the lease. The check is made payable to them. Okay, so really boils down to, at this point, that all parties are going to have to come to an agreement of how that refund is going to have to be made electronically. Okay, because there are multiple parties. Okay, obviously the landlord, there could be several different ways that refund could be processed. So that's why the legislature basically said, hey, default is by check unless y'all come to some agreement. Okay, if it was like a single tenant, basically, the tenant could elect to tell the landlord, hey, deposit it to a bank account or whatnot. My reading of this is, if you, whatever way you accept rent, if you took rent by ACH transfer, for example, and the tenant could elect, hey, you do an ACH transfer back to them for the rent. Okay. But that's what you do with multiple parties. Mutual agreement to refund the deposit in some form or fashion that all parties can agree to. Everyone gets put on a check, basically. So hope that helps out. There are some special rules if tenancy is terminated for domestic violence. We'll cover that in a separate video, but that's kind of like the default rule right now. So landlords, if you're facing a situation about handling a security deposit, or you need help dealing with a tenancy situation, and you're in the Northern California area, feel free to reach out. We might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.